In 2026, the UK is expected to enforce some of the toughest immigration rule changes in decades, and according to policy briefings and migration analysts, millions of visa holders could be affected. Some experts warn that even people who have lived in the UK for years, working, paying taxes, raising families, may suddenly find themselves at risk because of technical rule changes. Imagine waking up to discover that a salary threshold increase, a small paperwork error, or a missed deadline could legally threaten your right to stay. It sounds dramatic, but for many, this could become reality. What if the rules you qualified under are no longer enough? What if the pathway to permanent residency quietly changes before you apply? And what if minor issues like travel history gaps or employer compliance problems suddenly trigger serious consequences? The government says these changes are necessary to control migration numbers, but critics argue the impact could be far wider than people expect. In today's video, we're breaking down the 10 new UK immigration rule changes coming in 2026, who they could affect, and most importantly, how you can protect yourself before it's too late. Stay with us, because number 7 might shock long-term residents the most. Number 1. Stricter income threshold for work visas. One of the biggest and most immediate changes expected in 2026 is the increase in the minimum salary requirement for skilled worker visas. In recent years, the UK government has already raised income thresholds significantly, and new proposals suggest even higher limits could be introduced. That means thousands of workers who currently qualify, or are close to qualifying, may suddenly fall below the required salary level. And here's the worrying part. This doesn't just affect new applicants. It could also impact visa renewals and extensions. The government argues that raising the salary threshold will reduce net migration and ensure that only high-value roles are sponsored. On paper, it sounds like an economic strategy. But in reality, many essential workers, especially in healthcare, education, hospitality, and tech support, may find themselves caught in the middle. Imagine working legally in the UK for 3 or 4 years, building your life, paying taxes, and then discovering your salary is now £3,000 or £5,000 short of the new requirement. What happens then? If this rule takes effect, preparation will be critical. First, check your current salary against potential new thresholds. Don't assume you're safe. Second, speak to your employer early about possible pay adjustments or role upgrades. Some companies may be willing to review contracts to retain skilled staff. Third, make sure your employer remains a licensed sponsor in good standing, because compliance will matter more than ever. A small salary gap could become a major immigration problem unless you act before the changes arrive. Before it's too late, subscribe now to protect your future in the UK, because one update could change everything. Number 2. Tougher rules for family visa sponsorship. For many migrants, the ability to bring a spouse or partner to the UK is not just paperwork, it's about keeping families together. But in 2026, family visa sponsorship rules could become significantly stricter, especially when it comes to the minimum income requirement. The government has already raised the financial threshold in recent years, and further increases are being discussed. If implemented, sponsors may need to earn substantially more to bring their husband, wife, or partner to live with them legally in the UK. The official reasoning is clear. Policymakers argue that families should be financially self-sufficient and not rely on public funds. However, critics point out that the income requirement does not adjust equally across regions. Someone living in London may meet the threshold more easily than someone working the same job in a smaller city. That creates a serious imbalance. Imagine earning a stable income, paying rent, managing bills responsibly, but still being told you don't earn enough to live with your spouse. It's a painful reality that many families could face. If you're planning to sponsor a partner, preparation is absolutely essential. Start by reviewing your annual gross income and checking whether you meet potential future thresholds. Remember, only specific types of income count. Not every financial source qualifies. Keep organized records of payslips, tax returns, and bank statements. If you're close to the limit, consider whether overtime, a second eligible job, or career progression could strengthen your application. And most importantly, don't wait until the rules officially change. Acting early could make the difference between approval and separation. Before it's too late, subscribe now to protect your future in the UK, because one update could change everything. Number 3. Graduate visa restrictions and shorter stay periods. The UK's graduate visa route has been a lifeline for international students, allowing them to stay and work after completing their degree. But in 2026, this pathway could face major restrictions, including a shorter post-study work period and tighter rules for switching into long-term work visas. For thousands of students investing tens of thousands of pounds into UK education, this change could completely reshape their future plans. Right now, many graduates rely on the 2-year post-study work window to gain experience, build professional networks, and secure employer sponsorship. However, policymakers have expressed concerns that the graduate route is being used as a long-term migration pathway rather than a short-term opportunity. As a result, proposals include reducing the visa duration or limiting the types of jobs graduates can take before switching to a skilled worker visa. Imagine finishing your degree, celebrating your success, only to discover you now have far less time to secure a qualifying job offer. If you're currently studying in the UK, planning ahead is critical. Start researching licensed sponsor employers before you graduate, not after. Tailor your CV toward roles that meet skilled worker salary thresholds. Attend career fairs, build LinkedIn connections, and apply early. Timing could become everything. Also, keep track of visa deadlines carefully. Even a small delay in switching categories could create serious immigration complications. The graduate visa may still exist, but in 2026, it might offer far less flexibility than students have come to expect. Before it's too late, subscribe now to protect your future in the UK, because one update could change everything. Number 4. Expanded deportation powers, even for minor offenses. One of the most concerning proposed changes for 2026 is the possible expansion of deportation powers, including broader definitions of what qualifies as a public interest removal. In simple terms, this could mean that offenses previously considered minor may now carry much more serious immigration consequences. And this doesn't just apply to serious criminals, it could affect ordinary visa holders who make mistakes. The UK government has long maintained that foreign nationals who break the law should face strict consequences. While that principle isn't new, what may change is the threshold for action. Proposals suggest faster removal processes, reduced appeal rights in certain cases, and stronger enforcement against those with criminal records, even if the sentence was relatively short. Imagine being involved in a minor altercation, a driving offense, or a misunderstanding that leads to a conviction. In the past, it might have resulted in a fine. Under tougher enforcement rules, it could now trigger a review of your right to remain in the country. This is where awareness becomes critical. First, understand that immigration status and criminal law are closely connected. Even small legal issues can escalate. If you are ever charged with an offense, seek legal advice immediately from a solicitor who understands immigration law. Do not assume that because an offense seems minor, it won't affect your visa. Second, always comply strictly with visa conditions. Prevention is far easier than appeal. In 2026, the margin for error may become much smaller, and protecting your record could be more important than ever. Before it's too late, subscribe now to protect your future in the UK, because one update could change everything. Number 5. Faster asylum decisions and quicker removals. Another major change expected in 2026 involves the UK's asylum system. The government has been under pressure to reduce backlogs and speed up case processing, and new proposals suggest faster asylum decisions with shorter appeal windows. On the surface, that may sound efficient. But for many asylum seekers, quicker decisions could also mean less time to gather evidence, find legal support, and prepare a strong case. Officials argue that accelerating the system will reduce long waiting periods and discourage false claims. However, critics warn that speed should never come at the cost of fairness. Imagine arriving in a new country after fleeing danger, trying to understand complex legal procedures in a language that may not be your first, and now being told you have even less time to submit documents or challenge a refusal. A missed deadline or incomplete paperwork could result in removal before someone fully understands their rights. If these changes move forward, preparation will be absolutely essential for anyone seeking asylum. Submit complete and detailed documentation as early as possible. Keep copies of every form, letter, and piece of evidence you provide. If English is not your first language, request interpretation support immediately. Most importantly, seek qualified legal advice at the earliest stage, not after a refusal. Acting quickly could protect your ability to appeal. In a faster system, delays become dangerous. The process may move quicker in 2026, but your awareness and preparation will need to move even faster. Before it's too late, subscribe now to protect your future in the UK, because one update could change everything. Number 6. stricter compliance checks for student visa holders. If you're studying in the UK, this next change could directly affect you. In 2026, authorities are expected to introduce stricter monitoring and compliance checks for student visa holders. This means universities may be required to report attendance, academic progress, and even engagement levels more closely than ever before. Missing classes or falling behind academically might no longer be seen as just a university issue. It could quickly become an immigration problem. The government's reasoning is centered around preventing visa misuse. Officials argue that some individuals enter the UK on student visas but fail to genuinely participate in their courses. As a result, compliance rules may tighten, and institutions could face penalties if they do not properly monitor international students. Imagine missing several lectures due to illness or personal stress, assuming you can catch up later, only to receive a warning that your absence has been reported to immigration authorities. Under stricter rules, repeated non-attendance could even lead to visa cancellation. So what can you do to protect yourself? First, maintain consistent attendance and communicate proactively with your university if you face difficulties. If you're unwell or dealing with personal issues, document everything and inform your academic advisor immediately. Second, ensure your contact details, address, phone number, email, are always updated in both university and immigration systems. Finally, avoid working beyond your permitted hours, as work restrictions are often closely monitored. In 2026, being a student in the UK may require more than academic focus. It will demand careful attention to compliance. A simple oversight could carry much bigger consequences than you expect. Before it's too late, subscribe now to protect your future in the UK, because one update could change everything. Number 7. Indefinite Leave to Remain, ILR rule changes. For many migrants, indefinite leave to remain, also known as ILR, is the ultimate goal. It represents stability, security, and the freedom to live and work in the UK without visa restrictions. But in 2026, proposed changes could make this milestone harder to reach. Discussions include extending the qualifying residency period and tightening the rules around time spent outside the UK. For long-term residents, this could be the most shocking change of all. Currently, many visa routes allow individuals to apply for ILR after 5 years of continuous lawful residence. However, policymakers have debated whether that time frame should be extended in certain categories. In addition, stricter absence limits may be enforced more rigidly. Imagine living in the UK for nearly 5 years, planning your permanent settlement, only to discover that frequent travel for work or family emergencies has pushed you beyond the permitted number of days abroad. Even small miscalculations in travel history could delay or jeopardize an ILR application. If you're working towards settlement, tracking your residency has never been more important. Keep detailed records of every trip outside the UK, including dates and reasons for travel. Check your passport stamps and flight confirmations regularly to avoid errors. Make sure your visa status has remained continuous, with no accidental overstays between renewals. If your 5-year mark is approaching, consider reviewing your eligibility early with a qualified advisor. In 2026, ILR may still be achievable, but the margin for error could become much smaller. Careful planning today could protect the permanent status you've worked years to. Before it's too late, subscribe now to protect your future in the UK, because one update could change everything. Number 8. Expansion of digital immigration status enforcement. In 2026, the UK is expected to move even further toward a fully digital immigration system, and that could bring new risks for visa holders. Physical documents like biometric residence permits are gradually being replaced with online immigration status records. While the government says this improves efficiency and security, it also means your legal right to stay may depend entirely on what appears in a digital database. The shift to digital status allows employers, landlords, and even banks to verify immigration permission instantly through online checks. On the surface, this sounds convenient. But imagine logging into your immigration account and discovering an error. Perhaps your visa expiry date is incorrect or your work rights are not properly updated. Under expanded enforcement, these digital records may be treated as the final authority. A system glitch or outdated information could delay a job offer, rental agreement, or even raise compliance questions. So, how can you protect yourself in a digital-first system? First, regularly log into your official immigration account and review your details carefully. Don't wait until you're applying for a job or renewing a lease. Check your visa type, expiry date, and permitted work conditions. Second, keep copies, both digital and printed, of approval emails and visa decision letters. While the system is online, personal backups are still valuable. Finally, update any changes in personal details immediately, including passport renewals or address changes. In 2026, managing your immigration status may feel less visible, but staying proactive behind the scenes could prevent serious complications later. Before it's too late, subscribe now to protect your future in the UK, because one update could change everything. Number 9. Tougher employer penalties and increased sponsor audits. Another major change expected in 2026 focuses not just on migrants, but on the employers who sponsor them. The UK government is planning stricter enforcement, heavier fines, and more frequent compliance audits for companies holding sponsor licenses. And while this may sound like a problem for businesses, it can directly affect the workers they sponsor. Under tougher rules, employers could face unannounced inspections, detailed record checks, and severe penalties if they fail to meet sponsorship duties. If a company is found non-compliant, even due to administrative mistakes, its sponsor license could be suspended or revoked. Now imagine this scenario. You are legally working in the UK under a skilled worker visa, doing everything right. But your employer fails an audit. If their license is revoked, your visa could be curtailed, meaning you may have only a short window to find a new sponsor or leave the country. That's a stressful position to be in, especially if you have family depending on you. So what can you do? First, confirm that your employer is a registered and reputable licensed sponsor. You can check official sponsor lists to verify their status. Second, keep copies of your certificate of sponsorship and employment contract. If something goes wrong, documentation matters. Third, stay alert to warning signs. Late salary payments, contract inconsistencies, or unclear HR communication could signal compliance issues. In 2026, your immigration security may depend not only on your actions, but also on your employer's ability to follow the rules carefully and consistently. Before it's too late, subscribe now to protect your future in the UK, because one update could change everything. Number 10. Expanded enforcement of no recourse to public funds rules. The final change that could impact millions in 2026 involves the stricter enforcement of no recourse to public funds, often called NRPF. Many temporary visa holders already have this condition attached to their status, meaning they are not allowed to claim certain government benefits. However, under proposed reforms, monitoring and enforcement of this rule may become far more aggressive and automated. The government argues that this condition ensures migrants remain financially independent and do not rely on public support. But the reality is more complicated. Not all benefits are clearly understood, and many people accidentally apply for assistance without realizing it could affect their immigration status. Imagine facing unexpected financial hardship, perhaps due to job loss or illness, and applying for support, only to later discover that doing so has triggered a visa compliance review. In 2026, digital data sharing between government departments may make it easier to detect even small breaches. So, how can you protect yourself? First, clearly understand what counts as public funds and what is not. Some services, like NHS healthcare and public schooling for children, are generally allowed, while certain income-based benefits are restricted. If you are unsure, seek proper advice before submitting any application. Second, keep records of your financial situation and employment status. If your circumstances change significantly, explore whether you may be eligible to request a condition change legally. The key takeaway is simple: never assume. Under expanded enforcement, even unintentional mistakes could carry serious immigration consequences. Before it's too late, subscribe now to protect your future in the UK, because one update could change everything. The changes we've discussed today are not just policy updates buried in government documents, they represent real consequences for real people. From higher salary thresholds and tougher family visa rules to stricter compliance checks and expanded deportation powers, the immigration landscape in 2026 could look very different from what many migrants are used to today. And the most important thing to understand is this: most immigration problems don't start with major crimes or intentional wrongdoing. They often begin with small misunderstandings, missed deadlines, or lack of preparation. If you are currently living, studying, or working in the UK, now is the time to become proactive. Review your visa conditions carefully. Track your travel history. Confirm your employer's sponsor status. Double-check your financial eligibility if you're planning to bring family members. These are not dramatic steps, they are practical protections. The people most at risk in 2026 won't necessarily be those who broke the rules. It may be those who assumed everything would stay the same. But remember, immigration policies can evolve, and proposals can change before becoming law. That's why staying informed is your strongest advantage. Knowledge gives you options. Preparation gives you control. If you found this breakdown helpful, make sure to like this video, subscribe to the channel, and turn on notifications so you never miss an important update. And in the comments below, tell us which of these changes concerns you the most. Your experience might help someone else. Finally, this video is for educational purposes only and should not replace professional legal advice. Always consult a qualified immigration solicitor for guidance tailored to your situation.